So we're going to go ahead and get started here. So thank you all for attending. We are here today for the ICWA/MIFPA Best Practices in Minnesota District Court CLE put on by the Metro Urban Indian Directors Family Preservation Committee. So I would like to welcome you here today. This is being recorded, so it will be available online just on YouTube. If you have not signed in yet, we do have CLE credit sign in over in the corner there. We have a number of panelists here, and since we have a number of experienced ICWA practitioners here, we'd also invite you to be part of the conversation, and if you have things to add, certainly jump in. So we have a number of panelists from across different areas that will be providing some best practices and tips from their work and experience. So we have Michaela Maxwell from the, Minneapolis American Indian Center. And then Ann Gwenzis, the managing attorney at the Children's Law Center of Minnesota, and Shannon Smith from the ICWA Law Center, and Jody Aholina, who is an ICWA guardian ad litem attorney, Sarah Westrom, who is an assistant Anoka County attorney, Judge Bruce Manning from Hennepin County, who I believe is one of sort of the main Hennepin County judge for ICWA cases.
Judge Redding or Judge Rattel.
Two judges, and then let's see, Shanna King, parent mentor here also. So having trouble reading your sign. That's okay. It's not for me. But anyway, we have a number of questions and we will go ahead and get started. So the first question is about sort of the MIFPA inquiry. So under the Minnesota Indian Family Preservation Act, social services needs to inquire if there is reason to believe that the child involved is an Indian child. Social services agencies sometimes just isn't sure what to do. Why is asking, are you Indian, just that not sufficient? So anybody want to jump in on that one?
Too narrow. Start with that. It doesn't get to what you're asking.
Okay. And are there reasons that people might say no when the answer really is basically yes?
Yeah, I think because you're looking more broadly. And so they have kind of a narrow stream. They may not perceive themselves being a certain way when their heritage for sure qualifies the case for everyone.
I think it's really important that, I mean, ultimately it's the tribe as a sovereign nation who's going to determine that. And so in the context of the family's kind of history and their experience too, there's historical reasons why some families may have been separated from their tribal community. They may not know connections within their family. And there's some, I mean, going back historically, right, there was some really purposeful actions by the federal government and by other governments in regards to separating people from their identity very purposefully. And so sometimes families will not, they don't know, or sometimes they have really learned and experienced in regards to not trusting why people are asking. So I think it's really important to open up the conversation and ask it in a way so that the information is gathered and not asking the family to make that determination, because ultimately it's the tribe who makes it anyways.
I also think it's important to remember who is asking and when. If you're asking as soon as the children have just been removed from someone's home, they may not really want to talk to you about that kind of stuff. They might want to just figure out what's going on with their children. And so I've certainly seen cases where the parent denied having any affiliation to the social worker. We get to court, and then when the judge asks, then we get all this new information we didn't have before. So it's important to keep asking and making sure different people are asking and that we're asking that broad question. Because if you're asking, are you enrolled in a tribe? They might say no, but that doesn't mean that their child isn't eligible for membership or that the tribe wouldn't intervene. And so it's really important to make sure that there's that same level of understanding of what the question is.
And I think a lot of times just asking that question, are you Indian, excludes Alaska Natives, and ICWA applies to Alaska Natives too. And a lot of people don't kind of differentiate and ask those broader questions. And are you Indian is asking someone sometimes, how do you self-identify? As opposed to asking, do you have any heritage in your family on your mom's side, on your dad's side, and just kind of exploring it that way. Another thing that we in the Guardian program try to train on is preface it sometimes depending on the tenor of the conversation, but there are additional protections and laws that apply to families. And so from my perspective, I would rather have people say that they think they are or they are and have a tribe rule that out than than having some families be missed.
And I would just add in that, and tribes want to get in sooner than later. I'd rather know, and if it turns out that it's not a Mille Lacs child or a Leech Lake child or whatever, then we can do something then, but you don't want to start behind to begin with, right?
And recently, since the enrollment has been slowly shifting from, Red Lake, the enrollment requirement, it could impact the future eligibility of children in CPS.
Yeah.
And Yankton Zoo just recently did that also.
Right, so one of the requirements is not just to sort of ask once and be done, right? It's important that you keep inquiring during the case, because the answer could literally change, or you could just get more information once you've been working with the family for a while.
Sorry, what was the second, Michaela, what did you say after Red, like you said, someone, so and so?
Yankton Zoo
Yankton Zoo, okay,
also
thank
did
you.
that recently, yes.
Okay, good.
And the other thing is, are you Indian? I've had people contact me, they were not American Indian, they were East Indian.
Yeah.
And so they wanted to know what are the rules for East Indian. But the question was asked, are you Indian? Because if you're Indian, the Indian Child Welfare Act applies.
Right.
And so I've had, not very many, but a handful of people contact me and said, you're for American Indian, what about the East Indians?
So parents have the right to offer evidence and weigh in about major case decisions like whether alternative permanency should be granted. Beyond attending hearings and being a party, how can and should tribes be involved in court cases?
I think tribes should be invited to the process the minute you get a report from social services, and whether that's screening with the tribe if they're available, consulting about what services might prevent a removal, what supports are available. The earliest the tribe can be involved, the better. And the more involved, the better. So that way decisions are being made in a joint way, which is, I think, what's required under the law, but also leads to better outcomes.
Well, tribes are parties, right? So I think like the idea that sometimes I hear like language about, well, we're gonna consult with the tribe, which fine, but they're also a party, so they can bring their own, their own motions, their own, I mean, they're at the table and they're part of the entire proceedings. So they actively, having them, like Sarah said, actively engaged or a part of it tends to move things along in a much better way, I would say.
So this is a broad question, but I'm wondering if you guys can address a little bit about why active efforts are required and why that is part of ICWA.
Shannon, you're the one who teaches statewide. You have a variety of CLEs, and I think we could all probably chip in there, but.
I mean, active efforts are required because prior to the Indian Child Welfare Act being passed in 1978, there were practices that were intentionally, I mean, they were genocidal policies, right? We were going to separate children from their families purposely using education, using adoption, using all these kind of ideas about things that were very powerful in regards to separating children from their families. And ICWA, when it was passed in 1978, recognized that without keeping children connected to their tribe, to their families, that tribes would not exist. And so for future generations, having families connected and together was absolutely best for those children, but ultimately necessary for the future of tribes. And so active efforts was really a response to these policies, these horrific policies that were purposely separating families and keeping them apart. And so this idea of being responsive to families in a culturally sensitive, trauma-informed way. I mean, those weren't necessarily the words that were used in ICWA in 1978, but I think when you look at everything that was going into it, that's exactly what was happening. We need to respond to families in a way that is meaningful to them, and in a way that is culturally significant in regards to how we respond. So I think the why of active efforts is really a reflection of the horrific history that got us to the point of the Indian Child Welfare Act. How we respond with active efforts, I will let someone else take that away.
Well, I think it's going that extra step. It's realizing that if you tell a parent, hey, call me if you need help setting up that assessment, the parent doesn't have that trust because of that historical trauma. You have to go a step beyond that, 2 steps beyond that. You call the parent with you, you call the service provider, you take them to the service provider. You take those steps because we want to try to keep that family together, doing everything we can and knowing that we are doing our best to do that. And so again, it's just going above that extra step to help that family, help overcome those extra barriers.
Also, some of the families don't have the tools, or they never learned that from their parents who might have been in boarding school and they never learned those tools also. So the historical trauma passes on, like even simply filling out job applications, or like you said, setting up assessments, they never learned that. So it's really good to have workers to help them, assist them in that process.
And so following up on that, I'm wondering if you could address a little bit about the difference between reasonable act and active efforts. And if any of you can share cases where you feel that the extra requirement for active efforts actually made a difference in the outcome of a case.
Okay, me.
I'll share a few examples that I've seen reoccurring. And it's when the agency will provide active efforts to a relative to help them through the licensing process. That can be such a barrier to relatives for so many reasons. And actually helping that relative go through the licensing process, or bringing them and helping them, refer them to the tribal licensing process or AFAX, or getting that going and helping them also address barriers. So if it's seeking a variance, not just telling them you have a right to seek a variance, but here, we're gonna help you through this. Sandy Whitehawk, I know many of you know who she is, an elder. And she shared a story one time where she was in Canada and there was a panel and there was a mother who was sharing, and she had thanked the child welfare system and said, if it weren't for you, those child welfare workers on my team, I would not have my children in my care. And I thought, that's active efforts. That's all of us doing everything we can to try to help that family stay together. Not the model that I hope I'm the only one who has heard this, but probably not. I'm not gonna do more on your case than you're doing.
That makes me think about, like, we've talked a lot at our office about the idea of when someone is in crisis, if it's our own family or a neighbor or a friend, that like the human response is to do more, right? You respond to someone that is hurting by helping, provide food, go for a walk, offer to help take care of their children for a period of time. And the response for families who are in crisis in the child welfare system, instead of responding to them and actively engaging in that, is so often to ask them to do more, right? We put more on them at a time when they're in crisis and they're hurting, and then we wonder why it doesn't work. And the human kind of ability to do more when you're in crisis and when you're not in a place of being able to, you know, maybe even get up or maybe, you know, figure out what the next step is and then do more and more, you know, we do like another assessment, oh, let's do another UA, and we keep on adding and adding versus really responding to where families are at. And I think that's active efforts, right? Because it does happen. I mean, there absolutely are times where a family who's in crisis has a meaningful response and they're guided to kind of through the process, but more, I think way too often we see them being asked to do more and more at a time when they're coming to us in a place of hurt.
I feel obligated when we're talking about the difference between reasonable and active efforts to, you know, because we've only said the word once, that the difference springs from not just the history, but from the sovereign status of Indian tribes. And so particularly when a question is framed between compare what Native children get and non-Native children get, I think there's an invitation to misunderstand where this particular system comes from and why. So I'm mostly saying that. I think most people in this room understand that, but hello to people watching on YouTube. I have a single docket. I only do Indian child welfare cases, so I don't have to spend a lot of time thinking between, well, would we do this in a reasonable effort standard? Would we do this in an active effort standard? Two of the other judges in Hennepin do both kinds of cases. And I think most judges around the state do both kinds of cases. And so they may have more insight into whether they can draw clear lines in their head between, well, that's not required here because we're only using reasonable efforts. I will say that my experience has been, and the law is fairly clear, that the standard for reasonable and for active efforts tends to vary with the county. And the law is designed that way. It's sort of, this is the standard of care in this county, and your standard of care in this county when addressing a Native family needs to be higher, whatever that might mean. I did have an opportunity to attend a statewide training for a couple of folks who, judges who do a lot of child welfare cases, and it included role playing, which is a form of learning. And we had to rotate through, were you a judge, were you a parent's attorney, did you represent the agency? And when it came time for me to be the judge, we had a parent who was demonstrating sobriety, was having very positive visits with her hypothetical children, and looking for housing. And the particular point of that scenario was a notice question. It had just become clear to somebody at this late stage in the case that nobody had ever asked her if she was enrolled somewhere, and that's the thing they wanted to solve. But then I asked the parent's attorney, like, are you requesting a security deposit and first month's rent? And the rest of the room was like, why are you asking that, judge? And I was like, because in Hennepin that would get asked, and at this stage in the case it would get paid. And the rest of the state was just, you know, jealous, actually. And so I just want to at least like lift that up, that things move around. The law is fairly clearly intended that it needs to require more. And I think some of the examples that Jody shared and Shannon shared and that Sarah shared here, Kayla shared about what that actually means, help understand it. But just because reasonable efforts isn't a floor doesn't mean we shouldn't all be committed to raising the floor. Because kids deserve better than they get. Right, so like, anyway, I don't have as clear an answer for that as you might wish. I don't want to blow past Angel's raising her hand,
well,
so.
I would just add to that, defense attorneys need to ask. And when you go around, especially to outstate counties that don't deal with as many ICWA cases as the urban areas or some other, you know, areas of the state, they really don't know. And some counties still don't have judges that are trained in ICWA and so forth. So if defense attorneys, tribal attorneys, and, you know, maybe even social workers for counties and everything can ask, like you said, they said, oh my gosh, you're asking that? Well, if nobody has requested it, right? I mean, ask, you know, and make an argument as to why, you know, that is an active effort and why that should be accepted as active effort. And it should be, you know, and hey, judges should, you know, we need you to order that as active efforts, you know, please do that.
The only thing I would suggest is don't begin your argument with, well, they do it this way in Hennepin.
I don't like
I
that.
feel like that's gonna go badly, but the argument grounded in that says the only thing that's keeping this family from being reunified is that mom is not yet able to afford an apartment. She has a job, she's working 20 hours a week, she's hoping to get to 30 or 40 hours a week. And when we look at the overall cost to the county of the foster care system, which is harmful to the children because they're not with their parent, and the cost of investing in her rent, at least at the get-go. This should be an argument that makes sense. I would hope at least would get strong consideration across the state, but definitely beginning with they do that in Hennepin is a loser.
Well, I
No,
can't,
I wasn't advocating.
I know you're a better lawyer than that.
I can tell you what Carver County did pre-COVID. Judge Kane went around the entire courtroom and asked every single person in the courtroom, is there anything else that the county should be doing for active efforts, including me as the ombudsperson and the ICWA court monitor back then. Everybody in the courtroom that was there, that's what Judge Kane did. I'm not sure if it's still being done, but that's been done at Carver.
I think one thing that, and I've seen that, and I think it can be really effective. I worry, or this is probably like parent attorney, maybe,
You're also seeing
issue.
Which?
I do. No, but when, cause I've had parents be asked, like, what else do we need? And I feel like that can be a really difficult and harmful question, right? Because they might be in a place, especially at the beginning, not knowing what they need. And then it just kind of sets everything up for, again, this is on them. And I think, so I think it's really important question to ask. And I think as a parent attorney, like I'll often outside of the courtroom, like ask, you know, who I'm representing, you know, is there something that would be helpful, something we can do, something you need? But I think in the courtroom, I get, because I've had that a couple of times, and it just is like that sense of like being really deflated because they don't really know what they need at that moment in time, right? So I just think so I just wanted to note that because I think it's could be really hard.
I would say for kids, remember that they need services too to help, right? So if they're in out of home, they're confused, sad, angry, you know, and putting those therapeutic supports in place to help them process and sometimes anger, right? And so as we're trying to fix this problem, we have to provide them with the resources and the contacts and the people who are important to them and build their network as well. And that can help the family build theirs.
And do I have time to say something
Sure,
about that?
yep.
So, because I work all over the state of Minnesota, I see differences between other counties, and I don't always use Hennepin as the gold standard.
Inadvisable.
So that issue about like how can we best support the children? I think some counties do a great job about keeping children connected to their relatives, regardless of what might be happening with mom and dad. So aunties, uncles, cousins, whatever those important relationships, trying to help continue to facilitate those for the children. Other counties, like you have to do a supervised visit. Like they'll only let grandma have a relationship with the kids if she does a supervised visit. And maybe there's not room at the supervised visitation center because those spots are reserved for parents. So grandma doesn't get to have visits and the children don't get to have visits with grandma because that's kind of how that county is set up. And so I think really, you know, it's just a good reminder, Anne, about how the system really should be child focused. And what can we do to help support the kids?
Shonda, do you have thoughts on that? Like as far as like contact with family?
Well, yeah, so, hi, everybody. My name is Shauna, and I've been in the system as a youth and then as a parent. And I know when I was in the system as a youth, nobody asked if I was Indigenous, even though I think I look Indigenous. So ICWA was not involved. And I lost all contact with all my family completely, and there was never any active efforts. But then coming into the system as a adult, having active efforts in a system that really understood what I needed as a family was really important. And I have relationships with my family because of my tribal worker, right? Because they made sure that I had those visits and that they reached out to my tribe. and out to my aunties and stuff, and that was really made a big difference. And it made a big difference because I lost that as a kid, so coming in as an adult, I was able to reconnect, and I think that was important. I also had a really good judge who thought outside of the box for me. My son was disabled and I didn't get to see him for almost 3 months, and I don't know if it was a long time, but they thought about having visitations for me at powwows, which was really nice and really, reconnected me with just my culture. That was really important. It was really beautiful. Hard to talk about my stuff when I have like my attorney. Did I get that right?
Thank you for sharing. Thank you for sharing.
Yeah.
So what are some of the barriers that families can run into when they're working with counties and social services agencies that make it hard for them to really engage and trust and work with, the people that are trying to get involved in their lives?
I only see this at the very end, right? Because I'm in the courthouse, but it's worth starting from my perspective that the courthouse itself is a barrier. The courthouse itself is a representation that a system that has been harmful to you, been harmful to your family, been harmful to your aunties, uncles, grandparents, is now involved in your life. So at my stage of the process, it's not a barrier, the whole thing is a barrier, right? And so I think that is a question that pervades every aspect of what we do, and there's no part of it, including the court hearing, that is free of that weight and free of that desire that is not, here as I can tell, not just a desire of Native peoples, but it turns out none of us like other people in our business. And this is all about being in someone else's business, independent of what sort of history you might have around it. So the process itself is a barrier. And then I think it just gets worse. I think everybody at this table can give lots of examples of ways in which that manifests itself, but I'll take the first cut to say everything is difficult. And maybe people can expand on everything.
Well, I think it's not, the process by how we define it, right? Well, there's a couple of things. One is we define it as we want to strengthen and, reunite families. There's very little about the process that's healing. So if someone wants to engage in therapeutic services, they do it with the idea that someone else is going to have a release. And so right there is a barrier, right? Like you're not, the desire and to really heal, the system's not set up to do that. It's to check a box. And I know we always try to push away from that, but there's so many different times along kind of the process where it's checked back because like, oh, now I have to sign a release for this therapist. Or if you aren't able to develop a therapeutic relationship with someone, which a lot of us would be like, okay, I'm going to find another therapist, because even if they're a really good therapist, they might not be my therapist, right? The one that I feel comfortable with. In the system, kind of as it's set up, that's really difficult to do. Once you have a therapist, if you don't continue to follow or engage with that therapy, you become non-compliant or you're difficult or you just don't, so I think there's so many different places where the system, and I don't think it's so much even the individuals in the system, but it can become very punitive very quickly. And so it's not set up for people to heal and to be authentic, because if they are, they're pushed back to a place of like, oh, you got to do this again, or this isn't, so I think that becomes really difficult. And I'll just say this, and I think the other thing, just because I feel like is our system, and I think this is in Minnesota, it's the more I talk to people in different states, the Minnesota system as a whole is so driven towards permanency, but we don't really know what is this unattainable goal, because we really can't create this sense of permanency for kids, right? And we have a system set up that even a TPR is considered permanent, and we somehow celebrate that we've accomplished something. without knowing what's going to follow after that. So I think the way that our system as it is right now is set up, we're always pushing for something that isn't really what we want. And so, but we're all moving towards that direction because the statute tells us to, or that's been kind of how it's been talked about in Minnesota. So I think that's kind of my soapbox idea, but I think we really messed up in that sense, because we're always pushing towards something that even if we get there, we're not happy with, and ultimately it's not what's best for children.
And it's not real.
It's not real, because nothing's permanent.
Right.
You know, so like, yeah, so that's the other, yeah. I mean, we wouldn't ever say, you know, like all kinds of things happen in kids' life, but yeah.
And Shannon, how much of do you think that the timelines, the statutory timelines affect just what you're saying?
Huge.
Can you expand a little bit? I know that years ago you gave me the history of how the timelines
Well,
came in and
yeah.
you know, what the thought was, and it was a good thought, but you know, is it really, has it accomplished what the intention was?
Right, and I think, yeah, absolutely, and I think Minnesota has taken well, I shouldn't say, I know they've taken a more restrictive sense of the timelines than even, you know, was contemplated in the federal guidelines and statute. And so we had this, you know, we talk about this 12 months and, you know, when that's, so Minnesota's like, yeah, we're just gonna do this a little bit better, which I think is not the case. But I think at the time when it was, you know, we'll make it even tighter than the federal government. And so I think we've created some, I mean, we know that, you know, like there's generations of hurt and generations of trauma, and there's historical trauma, and then we're like, oh, you have 12 months to heal, see ya. And it's just like, doesn't make sense. So I think there's problems with that. I think also how we count the timeline in Minnesota. So, and I know there's been a lot of talk about this. So, but things like when a child is placed with a non-custodial parent, that's counting in the overall timelines permanency clock in Minnesota. Trial home placements are an issue in regards to how we count that timeline counts against permanency. So I think we've done some things in Minnesota that have really exaggerated the absurdity of trying to get to the place we want to go. I mean, if we, you know, so I think a barrier is it's just we don't have a place for families to heal. I mean, if that's, you know, if they are coming into the system and really have issues going on and we really want to have them walk away from the system in a place where they were better off than where they started, I think we have a lot of work to do in regards to understanding better how to respond to families in a meaningful way.
Bouncing off of Shannon, just the cultural and the whole interconnected of this is traditionally we didn't have like timelines and things just happened, you know, and for the mistrust also you're talking about a little bit about that. There's a big, huge mistrust, like you said, within the system and with the timeline just and the culturally difference. Like for example, like if like schools don't understand why we need to take so much leave for funerals, because unfortunately natives we lose a lot of people, a lot of relatives, and that's why we, you know, go to ceremonies or, you know, wakes for so long. And because of that, but the social workers like telling you, or some of them are like, hey, you can't miss anymore, but it's hard to work with the school and the social worker with your cultural beliefs too.
And that could be even outside of schools, right? That could be like a chemical dependency treatment center,
Yeah,
mental health treatment. If they're taking a longer period of time off, it can be difficult to explain why that is and get that sort of agreed upon.
yeah.
Anyone else want to talk about some of the barriers that they've seen? Yes.
I was just wondering if you guys, if anybody on the panel could speak to active efforts in a world where we are seeing long waiting lists and just a lack of, let's say, social support services as a whole. Because the one thing that struck me, Shannon, when you were talking is sort of about no space to heal and barriers. Well, I feel like our system is a microcosm of like our society as a whole. Absolutely. About that. So I just am curious as to kind of how you all maybe view active efforts in sort of some of the shortages, at least we are facing in my county, and long waiting lists.
I'll just take a little stab at that. So sometimes policy leads practice and sometimes practice leads policy. And I think if we have people who are courageous to stand up, county attorneys, judges, to say active efforts have not been provided in this case. And it's not because of lack of trying, it's because there are not resources and we are not moving to permanency. Then I think that if we have enough people doing that, the policy makers will get something figured out.
I think what I would advise in that situation is to make sure that that social worker is helping that parent get on every wait list. And making sure they're following up, they're writing letters saying this client their children aren't in the home because of this. And in making that advocacy as part of that active efforts, I think that that's a really critical piece. And showing, we can't make more beds in these programs. I've asked social workers to try. Still haven't taken me up on it. But I think going that step above and beyond of making that advocacy, calling all around, if you have to go out, whatever you have to do to get them the services as quickly as possible, because those timelines are tight for everybody. And I think that's important.
Now I feel the need to speak up. I was trying to sit out any discussion of the timelines. Every agency can meet the timelines. The requirement is to file a petition, and then the requirement for the judge is to have a trial. And if the agency hasn't been able to provide active efforts, they lose at trial. That's what happens. And then we've all met the timelines. Woo! And what we did was we broke the relationship between the social worker and the parents. We stressed out the kids who watch their parents, even if you try to protect them. We've stretched out the foster provider, who I hope is a relative at this point, and stressed them out. And we have used a lot of lawyer and social work resources to go to trial in order to say we went to trial. But the agency is not going to prevail if everybody agrees that mom needs inpatient treatment and nobody has a bed for her. So I think I can definitely make every timeline you put in front of me, no problem. The agency will lose a lot, and they'll know they'll lose a lot, right? The feds will be happy, I guess. But I think so. I just wanted to mention that at least part of the remedy is to pick up what Jody suggested, which is if active efforts or reasonable efforts aren't being made, they're not being made. And you need to ask the judge to find that it isn't being made. And I think the county's obligation at some point is to say, we agree, we're not happy. We wish we were able to do more for this family, but we can't really claim that the nearest treatment bed is available in Ames, Iowa, and that she should go take that, is an answer. And so the system can only work as well as the resources that are made available to it. The timelines can be handled in sort of dumb ways if you have to. But I think it would be pretty poor to get to a place that said we made all these referrals, we begged people for beds, they couldn't meet us, it's month 11, so we're gonna permanently render this family separate. Seems tough. I guess I would just, part of the training that the one I mentioned earlier, part of the training was to encourage judges to make findings of no reasonable efforts and no active efforts. That ABA had felt in reviewing Minnesota and in several other states that we had things that fell below the bar, even though the bar is defined on a county by county basis, and the judges were reticent to say that it is what it is.
Right, well, and I was
so
at that training too.
Right,
and-
so they were pushing us, right? We got a lot of
And I
pushing.
think one of the interesting things about that I think a lot of us who have who are in the system, we're so tied to, you need best interest reasonable efforts to get 4E funding. But it's really only tied to certain points within the case. It's not every single review hearing. If you're 9 months in or whatever, and you make a finding of no reasonable efforts, that does not necessarily equal no reimbursement. And I think that's not well known. I frankly didn't know that until I was at the training as well.
If I could just throw out there, Judge Manning, is it a situation where maybe you've heard people or would consider somebody making an argument that there's good cause to continue out the trial for protection of the rights of a party if they haven't gotten the services they need?
I don't want to speak for Judy Nord, but she would tell me I can't do that.
That'd be an argument.
I don't want to try to speak for either of the Judys, but, so I think the answer is no, but when the efforts aren't made, the efforts aren't made. And I think it's helpful at least to remind the judges, I found this helpful to be reminded of myself. I'm the judicial branch. Y'all screwing around in the executive branch, can't find your funding, lose your federal funding, not my problem, right? My obligation as the judge and the obligations that I hope attorneys would make to judges is I'm indifferent, sorry, to whether the agency gets its federal reimbursement dollars. My obligation is to law, the children and the parents. So I should be able to make the findings that are needed independent of that. But I am totally aware that we are all anxious that the agencies are underfunded and we don't want to do things that result ultimately in less funding. So then I think you have to be where Jody is and believe that if you squeak enough together loudly, the policymaking people will recognize that this needs more help.
I will just say, one of the things that I do as a county attorney is that I fall back on the rules of professional responsibility that require me to believe I have a good faith basis in anything I'm filing. So if I don't believe that I can prove by clear and convincing evidence that something, either whether it's the active efforts or the best interests of the child, I will use that not to file something.
And if the,
It's a totally interesting question, the ways in which the timelines, which we all complain about,
Right.
are actually indifferent to the legal standard that the attorney has to use to sign them. Sorry.
oh no, I'm gonna make the point on the reasonable active efforts is that if, you know, do it early, make the argument early in the case, right? And then it gets suspended and then maybe there's resources and then it comes back and then we're doing what we need to do. Don't wait until the 11th hour to make the argument about no reasonable efforts, make it early on.
I think it's probably more of a question, because I had not found the best way to kind of hold up, but I think a piece of it, the struggle that I have with either reasonable or active efforts is that not all providers are the same, right? So we get into the world, like just for example, chemical health. I mean, there are programs that are where I'm representing mom and she's like, oh, I'm gonna go to this program, and you're like, okay, we're gonna be okay, right? And maybe not, and maybe things will happen still, but there's just a sense like there's hope and there's a possibility, and there's other programs where you're like really, like, and I think that's the part of like the active reasonable efforts in the courtroom is that for a lot of judges, maybe not all judges, the fact that they're going to a chemical treatment program is all that matters, right? And where like you go sit down and visit them in that program, they're vastly different. And there's a vastly different amount of resources and, just kind of what their experience is going to be. And I think that in the courtroom does not get elevated enough. It's just assumed that if they're going to a program, they've been offered an inpatient chemical health, that's active efforts or that's reasonable efforts, when the quality between that program and a program somewhere else could be completely different experiences. And I think it's the same with assessments. It's the same with so many, therapy. And I think it's fundamentally unfair to that individual family, because if they're going to a treatment program, and we've all heard it, right? Well, everyone's using there, or there's, rodents going through all the time, or I walk out my back door and I'm being, approached to buy something, right? Like their experience at that treatment program, we've just set them up. If they're saying that this is stressful for them and this is not working, even if they're in a program, it doesn't feel reasonable or active to address that individual's needs. And I think that is a really huge problem in regards to the resource issue. Beyond just does it exist or not exist, is the quality of what families are experiencing and have to navigate.
So moving on to the next thing, we got a really good discussion going. So when you move to alternate permanency, like a transfer of custody or an adoption, can you talk about what are some of the best practices you've used or seen to keep a child connected to their tribe and to their extended family? Place them with family, yep. That is a good first step.
I mean, I think that's critical to do everything you can to have them with family, but unfortunately, there are times that's just not possible. And then if you have family members who are healthy and safe enough for visitation, if you can do contact agreements or at least build a relationship between the permanency option and the relatives so that they can continue engaging, having visits, phone calls, that sort of thing. And then cultural contact agreements, you know, having set things in place, consulting with the tribe on what that looks like, and how to best move forward and what opportunities might be available for that child moving forward. So I think it's really important to consider and to work with both the tribe and the family, the extended family, on how to make that happen, whether that's through a family group meeting or one-on-one meetings, but working extensively with everyone to figure out how to move forward.
And I would say, quite honestly, that dialogues with families about contact with siblings, with other relatives, just has to happen earlier, right? I mean, you don't do it a month before we're gonna finalize, and then we're feverishly passing around some sort of contact agreement. Having that dialogue so that the prospective family isn't surprised. They have an expectation that by having this child with them, they are going to have that child have contact with family members. And that's goes a long way.
And making that an explicit kind of agreement or conversation at the beginning.
Yeah,
right?
like an understanding. This child is very connected. I mean, we all know, we've all seen, and obviously representing kids, I sense it more, but so many times siblings are separated. So many times they're separated. And that loss is so hard for them. And letting the people know that, because, you know, we have different resolutions, right? We have one kid go here and the other kid go whatever. That's what we do. Making sure that they understand how important it is for those kids to continue to have contact with each other or with other important family members. Maybe that parent couldn't take them, but that grandmother is really important to them, and ensuring that that happens.
Another positive through my agency is like even after the case closed, I know my boss Laura has been working there for a while and we have a lot of their documents still, so it's really nice to still have some piece of their history with us, and they can come to the Indian Center and ask us questions. Hey, do you have this of mine? Hey, do you remember me? And more than likely we do, because we're small. Everybody knows a lot of people. Everybody knows everybody in Indian country, so yeah.
Michelle, I was on the contact agreements to make those part of the final order, to have those filed in, make sure that the order talks about that and they're attached, that so that there is a court record of that. And then whoever is not abiding by that, whether it's the parent or the custodian now, they have that document there to go back in and to try to enforce it. And so many parents that I used to represent, and when I was defending, if they did have some kind of agreement, it was usually not in writing, it was verbal, but if you in writing, they don't know where it is and they don't know how to enforce it. And so on the ones that I would do, I would say, you know what, we need to have the court look at this. It needs to be part of the record. It needs to be noted in the record that there is a contact agreement, and where did they go to do that? So I think we have to take that extra step. Besides just getting them done. And I was just at Mille Lacs band has added into their statute on permanent guardianships and transfers of custody, a contact agreement, not only with the family, but they have separated and also require a contact agreement with the tribe. And that consultation with the tribe too, which I had not seen in other codes, you know, before. And that's exactly it. And I think maybe as tribal, you know, attorneys, we also need to keep cognizant of the fact that we can do that, right? We can ask for a cultural contact agreement with the tribe, and we don't, I think that's another layer for family services to figure out and so forth. And I don't know, again, about resources. It's always a problem on you know, and tribal social services agencies as well as counties. But if it's there, you know, maybe we have a mechanism to use.
Jill, did you have a comment?
The other thing that I've seen more and more tribes are doing this, even if parents' rights are being terminated, it specifically states in the judge's order, because by agreement with the tribe, that child can come back and be enrolled with the tribe. Because when you terminate parents' rights, you terminate the rights to that entire side of the family, which means that that child is no longer considered Indian. But tribes are pushing to say, yes, at this time, as hard as it is, we are agreeing to terminate the parents' rights. But it is in there that when that child wants to become enrolled, that child would be eligible, and this is what they need to do.
So you could actually be stating that in your final order for terminating parental
Yeah,
rights.
But it's with the tribe's consent,
Yeah.
because the tribe has to say whether or not that the child would be eligible or not. But that is something that more and more that I'm seeing, more outstate tribes are pushing for this than in-state tribes. So that's
So-
something just to share with everybody.
Thank you. That's a good new practice to hear about that we can definitely look at. So we're coming up on the end of our time. I think I'm gonna move on to sort of a broad question, which is, do you have any advice for non-native people working with native populations on how to be culturally sensitive, especially on child protection cases where you're dealing with, you know, people at their lowest points in their lives and family and things that are really tough to deal with?
Coming from working in all the counties, just how you speak, professionals and, service workers too, how you speak to the parents and to each other in the tribes makes a great difference. We have mostly been uplifting, but there's a slight, it's been said that we focus on the negative more than the positive. So if we try to make more of it positive than negative, then that's very uplifting.
Anyone else?
Well, I'm gonna say, I say this a lot, I'm doing some work with foster families, and I really feel like if you're not open to learning or having this child keep their cultural identity intact, to find a different field to work in, just don't.
I think it's really important to remember that every tribe has different practices, every family has different practices and how they practice their culture. And it's important to be sensitive to that and empathetic to what their experience is. They may not have trust in that social worker, and there's a good reason that they may not have that trust from what their experiences have been or what they've been told. And so really coming at it empathetically and realizing that you might have to show up for that parent 20 times before they realize you're going to keep showing up and helping them, even if they're telling you off and closing the door in your face. And so really just keep trying, I think, is the most important part.
I think, so many of you probably know Julianne Chase Wilson, but she works at the law center, and she sent Sean and I a text this morning. And it just seems like really powerful right now, but it was just a quote, but it was that no matter what the policy is, it doesn't matter if you don't see me as human. And I think that it's exactly how you work with people.
Anyone else? Okay. So last question, this is again kind of broad. What is your advice for trying to follow the spirit of ICWA and MIFPA on child protection cases?
But everyone talk at once.
This is not the law, we're supposed to follow the law,
Yeah.
but following the spirit of cases, right? So, the reasons behind ICWA being created, the reasons for MIFPA, trying to make sure that we are doing better for Native families than historically as a system we have done. Can Aaron address that a little bit on how you can try to be faithful to that spirit of those laws?
Thing is doing the right thing, like Shannon said, to help heal. There are different things that ICWA is unclear about or doesn't specifically require. But if it's the right thing for that family or that tribe, then to me, that's following the spirit.
Think of it if it were your child, your relative, what would you want? That's how I tell people.
Thank you, Jill. So thank you so much to our panelists. really helpful advice. Obviously, all of you guys have a lot of experience on these cases. We're gonna go ahead and thank our panelists, and then if we have questions, I think we have a couple minutes. Any questions? Otherwise, we'll be here, so you can just walk up. Nope. Well, thanks so much. Take care.
Thank you,
Thank
guys.
you.
Great job.